Hi everyone, it's Ruby G.
And I'm Joff.
Welcome to Truth in Neurons.
In a 2024 court filing, a digital forensics expert with 30 years of experience training FBI and Homeland Security personnel was described by the presiding judge as offering pseudo-scientific testimony. His name is Cy Ray. His analysis indicated that vehicle and phone data did not place the defendant at the crime scene during the prosecution's alleged timeline. He characterised the case as exhibiting the worst investigative corruption he had encountered in his 3-decade career. He was excluded. Affidavit of Cy Ray, 25th of March 2025. Conclusion point 3. In my nearly 30 years of working with and for prosecutors all over the United States, I've never witnessed such a deliberate attempt by prosecutors to mislead the court on evidence in such plain sight. Anyone making such a claim would have to believe the court is incapable of reviewing physical evidence in possession of the state and defence. It rises to a level beyond a simple miscommunication or oversight, and is clear and intentional misrepresentation in the hopes to conceal a much larger issue. I respectfully request the court give this affidavit its due attention it deserves and explore these issues further. Then comes Bika Barlow, a DNA specialist with an international reputation, raised questions about mixture interpretation, transfer evidence, and laboratory protocols. Her concerns were minimised and her participation was limited. Along comes Brent Turvey, a forensic behavioural analyst known for crime scene reconstruction, identified injury patterns and dynamics that, in his assessment, were inconsistent with a lone actor timeline of 3 to 5 minutes. His framework was not admitted. What does it mean when defence experts are not merely disagreed with, but delegitimised? What happens to the adversarial process when questioning the state's theory is treated not as legitimate advocacy, but as professional misconduct? And how do cognitive biases, especially confirmation bias and narrative coherence pressure, turn courtrooms into echo chambers instead of testing grounds?
The adversarial model of justice rests on a foundational assumption that truth emerges through conflict. The prosecution presents its theory. The defence challenges it. A neutral fact finder evaluates the evidence under conditions of genuine uncertainty. The system does not require that the defence present an alternative theory, only that it tests the sufficiency and credibility of the state's case. But that model has always existed more cleanly in theory than in practice, and in capital cases where the stakes are existential and the pressure for closure is immense, the gap between theory and practice widens further. What we see is not adversarial process, but adversarial performance, a ritual that looks like challenge but functions like confirmation. Psychologically, this makes sense. Human condition is not wired for uncertainty. The brain's default mode is pattern completion, taking incomplete information and filling in the gaps to create a coherent narrative. Once that narrative is established, especially publicly and institutionally, the cognitive cost of revising it becomes prohibitive. Contradictory information is not integrated, it is rejected, minimized, or reframed as threat. This is not malice, it is motivated reasoning, and it operates at every level, from investigators to prosecutors to judges to the public. The adversarial system exists precisely to counteract this bias, but it only works if dissent is protected, not punished.
Confirmation bias is one of the most robust findings in cognitive psychology. Once we form a hypothesis, we selectively attend to information that supports it and discount information that contradicts it. In investigative contexts, this produces what researchers call tunnel vision, a narrowing of focus onto a single suspect or theory, often early in the investigation, with subsequent evidence interpreted through that lens. The danger is not that investigators form theories. Theories are necessary. The danger is when the theory becomes fixed before the evidence is complete, and when institutional structures reward certainty over revision. In the IDAHO4 case, the public timeline suggests that Brian Kohberger became a suspect relatively quickly. Once that occurred, the investigative and prosecutorial frame shifted from who did this to how did he do this. That is a cognitive pivot with profound implications. Evidence that supports the theory is highlighted. Evidence that complicates it is minimised or excluded. This is where the adversarial process is supposed to intervene. Defence experts are supposed to force the re-examination of assumption. They are supposed to ask, does this evidence actually mean what you say it means? Are there alternative explanations? Is the timeline physically possible? But when those experts are characterised as pseudoscientists or excluded on procedural grounds, the corrective mechanism fails. The courtroom becomes an extension of the investigation, not a check on it.
So let's focus on Cy Ray specifically, because his exclusion is emblematic of a broader pattern. Cy Ray's analysis reportedly addressed two critical claims: vehicle location and phone data. According to defence filings, his conclusion was that neither placed the defendant at the scene during the prosecution's alleged window. If Cy Ray's analysis is flawed, the appropriate response is cross-examination. Bring in a rebuttal expert, challenge his methodology, demonstrate why his interpretation of the data is incorrect. This is how adversarial process works. Instead, his testimony was excluded and his characterization as a pseudoscientist was entered into the record.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance records.
What evidence do you have that timing advance records existed that the state could have acquired for Mr. Kohberger?
Well, Your Honor,
I've read your affidavit of Mr. Ray, and he seems to entirely ignore the 7-day issue and doesn't address it.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. When Mr. Kohberger was identified, I'm going to jump ahead and tell you why I think I should get to ask Nick Balance about these records. When Mr. Kohberger came to the attention of the state and they began doing search warrants for Mr. Kohberger's records, on December 23rd, there were two separate search warrants for Mr. Kohberger's AT&T records, and they requested timing advance records. And one of the pages that we gave you was the carrier request that said, give us 7 days worth of timing advance records. There were 7 days back, at least 7 days back at that time. Those have never been produced to us. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for the time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
You've heard from AT&T that GLDC did not produce these records in 2022. You've absolutely heard that from AT&T. What you haven't heard is the other way that...
The other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once and they said, oh no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit, it's a glaring omission.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That,
So the 7 days that he's back home?
maybe.
I'll ask the state about those, if they receive those. I'm not sure their search warrant covered that time frame, but
Your Honor, I would say that it did, and I would say their first search warrant was just a 48-hour period. It asked for timing advance records, but then the second warrant,
you would
which...
agree there's no evidence that AT&T provided those, or that those were still available by the time that Mr. Koberger was identified?
Your Honor,
An officer of the court.
as an officer of the court, I would like to ask Nick Balance that, and here's why. Here's why. The things that I've learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
The evidence has been in the practice that I've learned from people that I've worked with.
You're giving me that testimony now?
I'm not giving you testimony. I'm answering the court's question.
Okay. But you've made some serious accusations against the state of hiding evidence, and yet you've provided no factual basis, zero, that that evidence existed for them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance
Because they were
records.
asked within 7 days of the date that they sought it. It was the tower dump from the night of the murder asked within the 7 days.
I understand that.
Okay? So where is the evidence that Mr. Koberger's timing advance records from AT&T were available to anybody in December without a prior request that they save those?
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't because they didn't know who he was.
You're correct. They didn't know who he was until, I think, about December 19th.
Correct.
Their warrant for his full scope of records, the second AT&T warrant, asked for all of the records. I haven't seen any of them. That's, even if they were just the 7 days back, I haven't seen any of
What
them.
you're talking about now is a discovery issue of those 7 days that don't sound like they're particularly relevant to the murder. That's a discovery issue you can take up with the court through a motion to compel, which you have not filed. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial.
Your Honor, we have litigated this issue quite extensively throughout the course of the case. The timing advance records, once I understood how timing advance works, became very important. We've heard different things now than I've heard at different times in the past particularly about the 7 days. That's newer information to me now. But the carrier request forms tell me I should at least have that. I want the court to know that we have had motions to compel on this very issue. We have had different bits of information.
For the 7 days that are after December, in December?
No, Your Honor, because the 7 days is something that's newer and has been brought to my attention
Our
more
motion to
recently.
compel related to timing advance records for November 13.
Our discovery requests were for all of Mr. Koberger's timing advance records. Our motions to compel covered all of them too. I have this carrier request now that says 7 days, and I have the affidavit now that says 7 days. Those are not things that I always knew when we were litigating this issue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that and you...
I understand your confusion and concern previously. What I don't understand it is now. In light of the evidence, I don't understand Mr. Ray's accusations without addressing the 7 days, that he had that information when he submitted his affidavit.
He is available to testify if the court wishes for him to.
It's his obligation and your obligation to establish that evidence of that the state has this, and you haven't done that. His affidavit is quite extensive, and he seems to ignore that issue.
Your Honor, I believe that that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days, and he supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got them in a way that they weren't supposed to at that time, for all I know. He didn't name names, he didn't identify it, he didn't put into any context. The state had indicated, and they provided AT&T's sworn testimony, that they only keep them for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that that was available to them by the time Mr. Koberger was on their radar as it relates to November 13. And I'm not seeing that as the problem.
My first question to Special Agent Balance, who would be the person who would have gotten these through a different channel, through the FBI, would have been, did you get them? Because I've heard different things along the case, asking him the question is really what I wanted to be able to do, and that's why I opposed this motion and prepared it as I did.
Tell you what, I'll let you ask that question outside the presence of the jury.
Thank you.
At the time of trial.
That will satisfy me. Thank you.
From a psychological standpoint, that is a red flag. Not because it proves Syray is correct, but because it suggests the system is prioritizing narrative protection over evidentiary scrutiny. When legitimate challenge is reframed as illegitimate distraction, the process is no longer adversarial. It is authoritarian. And here's the deeper problem. Once that pattern is established, it chills future challenges. Other experts see what happened to Syray, to Bika Barlow, to Brent Turvey. They see the professional cost of dissent, and they adjust, not because the evidence compels them to, but because the system punishes them if they don't.
Then comes Bika Barlow, a DNA specialist with an international reputation, raised questions about mixture interpretation, transfer evidence, and laboratory protocols. Her concerns were minimised and her participation was limited. Along comes Brent Turvey, a forensic behavioural analyst known for crime scene reconstruction, identified injury patterns and dynamics that, in his assessment, were inconsistent with a lone actor timeline of 3 to 5 minutes. His framework was not admitted. DNA evidence is often treated as definitive, but forensic DNA analysis is interpretive, especially when dealing with mixtures, low template samples, and transfer dynamics. Bika Barlow is one of the most respected voices in forensic DNA. If she raised concerns about mixture interpretation or lab protocols, those concerns should have been litigated fully in court, with cross-examination and rebuttal. Instead, her participation was constrained. Why? If her analysis is wrong, proving it wrong would strengthen the state's case. If her analysis is right, it would expose a foundational flaw in the prosecution. Either outcome serves justice, unless the goal is not truth testing but narrative maintenance. Psychologically, this again reflects the coherence pressure phenomenon. Once a narrative is publicly established, especially in a high-profile case, the cognitive and institutional cost of disruption is enormous. Careers are tied to the outcome. Reputations are on the line. Media narratives are entrenched. At that point, the system's incentive is not to interrogate the evidence more rigorously, but to insulate it from interrogation.
So lawyers who raise alternative theories face professional consequences, social ostracism, and even courtroom sanction. This is not anecdotal. This is documented across wrongful conviction research. In high-profile cases, especially those involving capital charges, defense attorneys who challenge aggressively are often characterized as obstructionistic, unethical, or complicit in re-victimizing families. This is psychological warfare masquerading as legal process, and it is devastatingly effective. Attorneys are human. They experience social pressure, reputational anxiety, and fear of professional sanction, just like anyone else. When the message is clear, challenge too hard and you'll be punished, the rational response is self-censorship, not because the evidence doesn't warrant challenge, but because the cost of challenging is too high. The result is a system that performs adversarialism without practicing it. Motions are filed, objections are raised, but the underlying dynamic is compliance, not conflict. And in capital cases, that is not just unjust, it is dangerous.
Organisations, like individuals, are motivated to protect their prior investments. Once resources, credibility and public commitment are tied to a particular outcome, the cost of reversing course becomes prohibitive. Sunk cost, they call it. This happens even when new evidence emerges, the so-called escalation of commitment in organisational psychology, and it's one of the most reliable predictors of institutional failure. In the justice system, this manifests as resistance to post-conviction review, hostility towards innocence claims, and procedural barriers to revisiting settled cases. But it also manifests during trial when institutional actors, judges, prosecutors, even clerks, subtly or overtly signal that deviation from the established narrative is unwelcome. This is not necessarily conscious, it is structural. The system is designed to move cases towards resolution, not to perpetually interrogate them. Finality is valued over accuracy, and once that value hierarchy is established, adversarial process becomes a performance ritual, not a functional safeguard.
When experts are excluded, not because their analysis is refuted, but because their conclusions are inconvenient, when attorneys are punished for zealous advocacy, when asking hard questions is reframed as disloyalty or cruelty, the system is no longer adversarial, it is inquisitorial, without the protections of an inquisitorial system. The psychological impact is profound. Witnesses self-censor, experts decline to participate, attorneys pull punches, and the public, conditioned to view challenge as disruption, applauds the suppression. The result is not justice, it is the appearance of justice, and in capital cases where the state seeks to take a life, appearance is not enough.
Syre said this case represented the worst corruption he'd seen in 30 years. Whether you agree with that characterisation or not, the fact that such a statement could be made by someone of his experience and then dismissed without full public examination is itself diagnostic. It tells us that the system is more committed to its conclusions than its process. And when that's true, no verdict, no matter how procedurally correct, can be trusted fully.